Good morning, everyone, and welcome to This Explainer. Today, we're diving into the fascinating legal concept of strict liability. We're going to unpack exactly how you can be held legally responsible for an accident, even if you did absolutely nothing wrong. I know, it sounds counterintuitive, but the law has a very specific mechanism for this.
Here's our roadmap for today. We'll start with the origin of strict liability, move on to the 3 essential conditions, look at the exceptions to the rule, and then wrap up with a quick summary and a final thought. All right, part 1, the origin of strict liability, a massive 19th century disaster.
So this entire principle evolved from a huge accident back in 1868 in the famous case of Rylands for Fletcher. Here's what went down. Fletcher decided to build a reservoir on his land to power his mill. But due to a terrible accident, all that water catastrophically flooded Rylands' neighboring coal mines. Rylands sued, and the court did something that shocked people at the time. They actually held Fletcher liable. They basically said, look, you built this huge reservoir at your own risk.
And that brings us to the absolutely crucial point here. Liability in this context doesn't require negligence. It arises simply because a hazardous substance was kept and it escaped, causing harm. The court decided that if you bring a hazard onto your property, you're on the hook for the damage it causes, period. Even if you weren't careless at all, you brought the hazard, so you bear the responsibility.
Moving right along to part 2, the 3 essential conditions, or the rules of liability. For a strict liability claim to actually hold up in court, all 3 of these specific conditions have to be met. We need dangerous substances, an escape, and a non-natural use of land. And remember, you can't just have 1 or 2 of these. All 3 must be happening at the exact same time. Let's break them down.
First up, you have to be keeping a dangerous substance on your premises. The law defines this as anything prone to causing mischief or harm if it manages to get out. We're talking about serious hazards here, like explosives, toxic gases, or high-voltage electricity. If it has a high potential to wreak havoc if it gets loose, it definitely fits the bill. Second, the substance actually has to escape. It must leave your property and get totally beyond your control. To put that into perspective, imagine you're growing a highly poisonous plant in your garden. If the wind blows those poisonous leaves onto your neighbor's land and their cattle eat them and die, you're strictly liable. But what if your neighbor's cattle wander onto your land, eat the leaves, and die? Well, in that scenario, you're actually not liable. Why? Because the leaves didn't escape your property. This was perfectly established in the case of Reeds v. Lyons & Co. Simply put, no escape means no strict liability. And that leads us perfectly into the 3rd condition, non-natural use of land. The law differentiates between everyday things and special hazards. Natural uses, like having domestic water storage, underground gas pipelines, or even a stray spark accidentally flying out of a normal fireplace, those won't attract strict liability. But storing massive volumes of water specifically to energize an industrial mill, just like Fletcher did, the court considered that a non-natural special use of the land. So, with rules that rigid, it kind of makes you wonder, if someone's property is damaged and all 3 of those conditions are met, are you just doomed? Is there any possible way to defend yourself in court? Luckily, yes. Let's look at part 3, exceptions to the rule, and the 4 defenses. If you ever find yourself facing a strict liability claim, there are 4 key defenses that can act as a get-out-of-jail-free card. These are the plaintiff's fault, an act of God, the act of a third party, and the consent of the plaintiff. Let's explore how each of these actually works in practice. Defense number 1 is the plaintiff's fault. There's a really interesting case here, Ponting v. Noakes. In this case, the plaintiff's horse wrongfully intruded onto the defendant's land, ate some poisonous tree leaves, and died. The court ruled the defendant was not strictly liable because the plaintiff's own horse was trespassing. Simply put, if the plaintiff's own actions are the reason the damage happened, you're off the hook. The second defense is an act of God. This completely excuses you if the escape happens purely because of an unforeseeable natural event that no human could possibly control. Think massive freak natural disasters. If Mother Nature steps in and breaks your reservoir and no amount of reasonable caution could have stopped it, you aren't strictly liable. Third, we have the act of a third party. The classic example here is the case of Box v. Jubb. A total stranger, someone who wasn't a servant or under the defendant's control at all, emptied his own drain into the defendant's reservoir. That caused it to overflow and cause property damage. The court said the defendant wasn't liable because a stranger caused the escape. Just a quick caveat, though. If that third party's act is foreseeable, you still have to take due care. And finally, our fourth defense is the consent of the plaintiff, or in legal terms, volenti non fit injuria. Let's say you and your neighbor willingly share a water source located on your land. If that water source suddenly leaks and floods their property, they can't sue you under strict liability. Since they consented to the shared arrangement, they accepted the inherent risks that come with it. All right, part 4, summary and final thought. Let's weigh this accountability. To sum up everything we've covered in this explainer, the 1868 case of Rylands v. Fletcher established a very powerful rule. If you keep a dangerous substance and it's a non-natural use of your land, and that substance escapes and causes harm, you are strictly liable. And the real kicker here, your level of care absolutely does not matter. The liability is imposed regardless of negligence. However, as we just saw, you can shield yourself. You are totally excused from this liability if you can prove the damage was triggered by an act of God, the unforeseeable act of a third party, the plaintiff's own fault, or if the plaintiff explicitly consented to the setup. Thank you so much for joining me today. I want to leave you with a final thought to ponder. As our property uses get more complex, more industrial, and honestly more hazardous in the modern world, is strict liability the ultimate form of fairness to protect innocent neighbors? Or does holding people legally accountable for accidents they didn't negligently cause place an unreasonable burden on us? Think about it. See you next time.